Lil Durk is in a whirlwind of trouble because if what is alleged is actually proved, he's got to be one of the dumbest people on earth. Or the government is just being brazenly stupid to the point where they want to make sure everything that he said and he's done basically ruins it. The stuff that they allege in this freaking document is 6 pages. I just get to the meat and potatoes of it. It's like 3 minutes. I'm telling you now, bruh, it's BA triple D. Take a listen. Stay to the whole video because even the next part, they responded to it, meaning Drew and all of them. It's 37 pages, but we don't read the whole entire 37 pages. I listen to y'all. Hey, it is what it is. If you want full document reading, I think we'll put that on the Clips channel. I think that's the best way to do it. Other than that, man, I'd have held y'all too long. Let's go. Very good. And then versus Banks and all his homies. Government's second supplemental memorandum in opposition to defendant Durk Banks' motion for a bill of particulars. Now, what we're going to scroll down to and get down to is basically, I want to say right here. All right, here. Here, the detailed SS1, together with the government's substantial and organized discovery, obviates the need for a bill of particulars because they provide clear notice to defendants of the government's murder-for-hire theory. The government has alleged in its discovery clearly supports the straightforward theory that defendant Banks told co-conspirators he would reward anyone who helped kill his rival Taquain Bowman. That defendant Banks and the other OTF co-conspirators attempted to murder Bowman in Los Angeles on August 18, 2020, and that even though the co-conspirators killed SR, not Bowman, defendant Banks nevertheless rewarded co-conspirators by, among other things, featuring many of the direct participants in the murder in music videos and rap lyrics in the months following the murder. For example, the government anticipates that a cooperating witness will testify that defendant Banks made clear to the witness and other OTF members that someone who killed Bowman would be made straight, i.e. handsomely rewarded. The discovery also shows that defendant Banks used his trusted lieutenants, defendant Wilson and co-conspirator 5. So they know who the hell co-conspirator 5 is. They really can't tell me that they don't. To recruit hitmen to fly to Southern California on August 18, 2022 to kill Bowman. Consistent with defendant Banks' promise to reward co-conspirators, defendant Wilson solicited hitmen by promising to pay $1 million, to pay a $1 million reward on behalf of defendant Banks in exchange for flying to Los Angeles to commit the murder. Moreover, the government has also disclosed a list of defendant Banks in OTF music videos in which defense Wilson, Houston, and others involved in the murder scheme are prominently featured following SR's death because the government's theory of the case is clear. Defendants' request for a bill of particulars should be denied. Indeed, the purpose of a bill of particulars is to enable a defendant to prepare for trial, to avoid or minimize the danger of surprise at the time of trial, and to afford protection of the double jeopardy clause in the event of a successful prosecution. It is not to force the government to preview the details of its trial strategy, and while defendants are rightfully entitled to meaningful discovery to present a defense, they are not entitled to a roadmap of how the government will attempt to prove its case, a laundry list of each act the government considers significant, or a flowchart of the government's advocacy theories, United States versus Rankin, stating that the defendant's constitutional right is to know the offense with which he is charged, not the details of how it will be proved. In light of the detailed SS1 and through discoveries setting forth the government's theory of this case, the court should deny the motion. Hold on. Before we get to it, free cash right there. Y'all know how to do it, Hit that QR code or tap the link in the description. Get paid $5 cash on Nash in your doggone profile as soon as you create one. Some of y'all failed to do that part. You had to sign up hitting the QR code or tap the link in the description. Just searching it on the goddamn store ain't gonna help you. The #1 finance app. Read the reviews. It's not a damn scam. We ain't doing that. Not over here. It's been too many scams that they wanted me to do. I just ain't do it. Free cash. Hit that QR code or tap the link in the description. Bruh, listen, man. I'm one of those people where I was like, yo, bro, hey, man, it's you can't be serious, right? That's one of the first things I'm doing. You can't be serious. But the second thing I was doing was like, if the government is right about this, Durk get what he get, bro. If the government is right about this. Because one thing for certain, two things for sure. We don't know what we don't know, but what we do know is that they are sticking hard to those lyrics. And I had said that crap before. I'm like, yo, bro, if they're sitting up here forcing these lyrics onto us, they have to know this shit gonna look horrible. They have to know, like, it shouldn't be what you guys are saying, but basically saying, oh, that freaking Durk rewarded them, like, oh, here's your reward. Y'all can get in the videos and shake your ass all day if you want to and all that crap. Listen, man, that is bad, because you do have to say eventually, damn, bro, y'all kind of messed up. Y'all putting this shit all in the government's face. But the government effed up. And what I mean is this. They said that DEDE said he gonna get him $1 million. But y'all dropped the bounty part of it. Y'all went against exactly what the hell y'all said. So I'm curious, how the hell do y'all go from saying, oh, it was $100,000 reward to $1 million reward to, oh no, all I'm gonna do is I'm gonna drop your name and some songs. Y'all even talked about them giving contracts and all of this shit. So the government is literally switching its argument. I think I could whoop the feds on this one. I think I could get in the damn paint with the feds on this one. Because in one instance, y'all said, oh shit, we had them meet up over burgers and cheese sandwiches and shit, and they exchanged the money there in LA. That didn't happen. Oh, let's drop the murder part let's drop the money that was given part, and let's switch that shit up. That part right there, massively flawed. So you telling me now it's all for them to say, oh, it's only going to be music features and y'all can be in the videos and all this crap, to now DEDE was going to pay for it? Yeah, I'm not smelling what the hell y'all selling. But let's get into what Drew and the Dream Team said, because they come after him. I'm not going to read the whole entire 37 pages, but I'm going to give y'all the good parts. Roll it.
So this right here, we're just going to get straight into what the hell they actually are talking about, right? So you have, obviously, United States versus Durk, and then it says, defendant banks joint supplemental brief in support of its motion to exclude proposed 404B evidence. Then it basically says, Durk and DEDE hereby files this joint supplemental brief in support of its motion to exclude proposed 404B evidence. Defendants request a hearing on the matter. This brief is based on the attached memorandum and exhibits the files and records in this case and any other evidence or argument that the court may permit. And you can see right here, this is what it is. And it says, defendants filed a motion in limine to exclude proposed 404B evidence on October 7, 2025, docket 258. The government filed its opposition on October 27, 2025, docket 274. Defendants banks filed a reply thereto on November 10, 2025, docket 289. On January 2nd, 2026, the government filed a supplemental opposition, docket number 328, and a pretrial hearing was held on January 7th, at which time the court directed the government to file a particularized notice of 404B evidence. The government sent the defense a renewed notice on January 16th, 2026. Undersigned counsel met and conferred with counsel for the government on January 23rd, 2026, and did not come to an agreement regarding the substance of this motion. Defendant Banks and Wilson hereby file this joint supplemental in brief support of their motion to exclude proposed 404B evidence in light of the most recent notice and request that all rap lyrics evidence be excluded from evidence in this case. And then they go on to go the hell off, right? So let's start with 4. I'm not going to read any of this. I'm going to just kind of throw y'all off real quick. Well, not throw y'all off, but show y'all how crazy it is. Because what it sounds like is they had a meeting today, and that meeting did not go how the hell they wanted it to. They went, look at all these damn cases right here. Bruh, 1, 2, 3, 4. Hold on. 1, 2, 3, 4, 5, 6, 7, 8, 9, 10. Hell of them, bro. Look at this shit. They are going in. So they already kind of telling me, meaning Durk and them, what the hell they truly plan to do. Look at all this shit, bro. They was ready. It's fascinating, right? Drew is saying, well, Drew and the team is saying basically, let's get rid of all the damn rap lyrics. Let's get rid of all the videos. Let's get rid of all of that shit. But the question really remains, because at first it does seem like, oh, the government is just using rap lyrics and all that shit and everything. And we can understand why you would want it thrown out. But do they make the point? Because all rap lyrics will not be thrown out. So you want to say all and then fight for which ones come in, so it makes sense. And I think the strategy here is like majority of strategies always are. I'm going to say all and then battle each and every one because there's no way psychologically you can say yes to all of this shit unless you're Euro Glanville from the YSL trial. Take that to motherfucking trial. Let's get on with the second part of this. So let's keep it rolling. Let's get to page 8, right? Memorandum of points and authorities. Background. Rap's historical roots and modern influence. So they're going to attempt to act as though the judge don't know nothing about rap music, and I think it's interesting. This right here, though, you might be pushing a little too much. Scholars posit that rap music began as an outgrowth of the slave trade. That's actually not true, but okay. Originating from a traditional African storytelling, often used to express economic frustration in the post-industrialized America. Adam Dunbar, Chris E. Krubin, and Nicholas Surich, the threatening nature of rap music. And this is the stuff that they put in the previous stuff. I just didn't want to read all of that shit. So in the early days, rap provided an artistic outlet for a marginalized group of Americans, specifically Black Americans, experiencing poverty and systematic oppression. See Christopher Holmes Smith Methods in the Madness, exploring the boundaries of identity in rap, hip-hop, and hip-hop performity. So if I'm them, I'm adding him to the witness list. And to this day, rap functions as both political commentary and social reporting. And it says rap is the CNN of Black America. Chuck D, a Public Enemy, a New York rap group which rose to prominence. We ain't doing all that. If y'all know who they are, y'all know who they are. If you don't, then get the hell out. Nah, I'm playing. It's old school rap for y'all who don't know. Anyways, to some, rap music is perceived as offensive, sexist, materialist, and lowbrow. And they basically talk about misogyny in rap music, a content analysis of prevalence in meanings, but 12 men masculinities through rap. Though rap has been adopted by many communities and across racial and cultural lines, rap is uniquely a Black art form. The manner in which the music became integrated into the fabric of American culture was a Black American cultural product through an overwhelmingly Black American audience in using Black American aesthetics as signature features of the music. Imani Perry, Prophet of the Hood, Politics in Hip Hop 2004. Rap is many things: artistic expressions, a symptom of systematic oppression, political and social commentary, and more. One thing rap is not: reliable evidence. The impact of rap music can be felt in almost every facet of American culture: advertising, film, fashion, language, social media, sports, and business. For many of the younger generations, rap music is the default musical language, not a niche genre. Through rap music in the music industry, young Black Americans have reached levels of immense success. Jay-Z began his career rapping about the life in the projects of Brooklyn and is now hip-hop's first billionaire. Kendrick Lamar won a Pulitzer Prize, and Dr. Dre has transformed himself from a groundbreaking California hip-hop rapper to a bona fide business mogul. Put plainly, rap music is widely profitable, and its popularity and mainstream success only continues to grow as the industry has become more commercialized. So too has the process of creating rap. Any given song might be the product of multiple collaborators in writing, producing, and engineering. Music videos are often subject to a system of checks and balances from corporate ownership. Even social media posts and interviews are utilized as mechanisms of branding. For young men and women, particularly those living in marginalized communities, rap music can be a shining beacon of hope, a vehicle that can potentially catapult them into generational wealth. So what they're really saying is, this is the need to rap. This is the need for rap. This is why people rap. And for the most part, it reads off kind of like, I hate to say it, like an opening statement to have people understand these things about rap. And I get it, but this is kind of opening statement and closing statement a little bit. So far, it ain't really doing nothing for me. What about y'all? Hit that like button like you like something if you can. Force this to the algorithm. I was supposed to get this to y'all an hour ago, but god damn, it was so much reading. But like I said, we ain't gonna do the whole entire 37 pages, so there's that. So let's continue on. And then we're going to skip down to page 15, right? We'll read a little bit of this. The government supplemental notice dated January 16, 2026 asserts that the music evidence is direct evidence and inextricably intertwined with the charges, yet provides no explanation of how rap lyrics created at unknown times by unidentified authors could possibly form part of the charged conduct or be necessary to tell a coherent story. The government identifies the release dates of several videos, but it does not identify when any lyrics were written or when the songs were produced. The government does not identify authorship, does not connect specific lyrics to any particular fact in dispute, and does not attempt to address the substantial prejudice that any such material would cause. The government also states that it reserves the right to supplement its notice and introduce additional excerpts without identifying what those materials might be. That's insane, by the way. This repeated assertion of reservation of rights is contrary to this court's order from the January 7, 2026 hearing. It impairs the defense's ability to prepare and prevent the court from performing its gatekeeping duties. The government has now made 3 separate Rule 404B submissions and still has not provided the required information. The evidence is not inextricably intertwined. The government has not satisfied Rule 404B, and the court cannot conduct Rule 403 balancing without a complete record because each of the deficiencies is independently sufficient to warrant exclusion. The court should bar all lyric and video evidence. Facts. The government has severed 3 separate disclosures identifying the facts that it seeks to use at trials. Evidence it seeks to use at trial. In each purported music evidence, it has changed its initial notice dated September 1st, 2025. The government identified 2 broad categories of proposed evidence: Banks' rivalry with Taquane Bowman, aka Quando Rondo, and Banks' alleged direction of violence against rivals, and concluded with generic statement that all listed acts were admissible to show defendant Banks' move, intent, preparation, and plan. Knowledge, identity, absence of mistake, and lack of accident without explaining how any particular piece of evidence served any particular purpose. The government's revised notice dated September 17, 2025, which I kind of pointed out already, asserted that the evidence described in sections 1 and 2 is direct evidence and inextricably intertwined with the charges in the second superseding indictment and allows the government to present a complete story to the jury. It is therefore not subject to notice pursuant to Rule 404B. The revised notice then stated, to the extent any of the listed evidence does not fall within the scope of Rule 404B, the government gives notice of its intent to use such evidence pursuant to this letter. The revised notice provides no articulation of reasoning, permitted purpose, or a logical connection between the evidence and any non-propensity use. Only at the end of Section 1 did the government include a fallback provision stating that, to the extent the court determines these acts are neither direct evidence of or intertwined with the charges, they are admissible to show co-conspirators, most of whom were members or associates of OTF, motive, intent, preparation, plan, knowledge, identity, absence of mistake, and lack of accident. Section 2 similarly stated the evidence is admissible both as direct and inextricably intertwined evidence pursuant to Rule 404B. My bad, y'all. This stuff just kind of blanked out. But provided no articulation of reasoning or permitted purposes of Exhibit B4. So on January 7, 2026, this court held a status hearing where it directed the government to specify which words and which medium is being proposed in order for the court to make an intelligent 403 ruling, docket 341 at 1920. In response to that directive, the government sent the defense a new 404B notice on January 16, 2026, which confoundingly includes entirely new evidence. The government supplemental notice dated January 16, 2026 identifies 12 separate music videos, audio recordings, and rap excerpts that it characterizes as music admissions. The government asserts that the evidence is direct evidence of inextricably intertwined with the charges in the second superseding indictment, and therefore not subject to notice pursuant to Rule 404B. It then states, to the extent any of the listed evidence does fall within the scope of Rule 404B, the government gives notice of its intent to use such evidence pursuant to this letter. Unlike the revised notice, the supplemental notice provides no articulation whatsoever of any reasoning, permitted purposes of logical connection between the music evidence and the non-propensity use. The supplemental notice merely summarizes the proposed significance of the music evidence by grouping into 6 broad categories of admissions and asserts that music admission evidence is admissible against all defendants as co-conspirator statements. The notices do not identify who authored the lyric, when the who authored the lyrics, when they were created, whether the defendants adopted them, or how the government connects each specific excerpt to any particular fact in dispute. The government does not acknowledge the potential prejudice that would result from the admission of the videos and songs, much less suggest a way to lessen any such prejudice. The government explicitly reserves the right to supplement this notice and/or provide additional proposed exhibits up to the April 21st, 2026 trial date, and further reserves the right to introduce additional excerpts of music videos depicting defendants together with charged and uncharged co-conspirators without any indication of what those songs might be. We reserve the right to supplement this notice as necessary before trial, despite this being the government's third attempt at notifying the defense of intended 404B evidence. It still fails to meet the required notice obligations. The government's notice of non-committal, non-specific, and fails to apprise the court of the information necessary to even conduct a proper 403 analysis, despite this court and the defense repeatedly requesting the specifics, even if it did satisfy the notice requirements. The rap lyrics and accompanying music videos are irrelevant, prejudicial, communicative, misleading, and would cause significant delay in this trial. The purported evidence must be excluded. So y'all just gonna drop music videos in there. That's what that says. Y'all gonna see, the thing that should happen, right, is just pictures. Just pictures. Y'all can point to this and say, oh, it's a reward. But now y'all trying to bring the people into it. But I kind of can see, right? Like, go back to the Young Thug trial, right? To the Young Thug YSL trial. If Lil Woody would have got arrested and they brought in, and let's say he was being charged with the murder of Donovan Thomas, even though he beat those charges, just want y'all to know that he beat those charges. If they would have dropped that Lil Woody pop at your noggin, bruh, we would have been sitting in that courtroom like, oh shit. So I think that's what the government is trying to, that's my clear belief. But Drew's right on the sense of, bruh, y'all need to say exactly what lyrics, because y'all just talking about the whole entire song. So we about to sit here, and Boosie had talked about this before. We about to spend a whole damn day listening to songs and then deciphering this shit. Yeah, I don't see how the judge really lets a lot of this shit in, but we shall see. Let's finish with this last one. This really gets good. Rejecting inextricably intertwined theory where government nowhere asserts that it would be difficult to establish its case without other acts. And then we're not going to keep on reading this United States shit, but no. The finding evidence is not inextricably intertwined with the charged conduct because the government does not assert that it could not establish its case against the defendant as to the charged conduct without reference to this evidence. 1, inextricably intertwined with charged bank fraud because it can relate to any number of criminal schemes unrelated to those charges. And they're talking about United States versus Brooks. So I might have to read some of this shit so y'all know what we're talking about. The government cannot satisfy either of the 2 narrow categories of inextricably intertwined evidence. The music evidence is not part of the charged transaction, and it is not necessary for the government to tell a coherent story. At the outset, the government cannot rely on the same criminal transaction theory because they failed to identify when any lyrics were written or when the songs were produced. Although the government identifies the premiere dates of multiple music videos, the music video's premiere date or song release does not establish when the content was created. A song could be in development for years before its release. Without the basic information, the court cannot determine whether the music evidence is temporarily connected to the charged conspiracy or too temporarily to distant qualify. Let me reread that, bro, because y'all not seeing this, but when I'm recording this shit, there's numbers. So let me get this shit out of there. Okay. is temporarily connected to the charged conspiracy or too temporarily distant to qualify as part of the same transaction, even if the lyrics were created close in time to the alleged conduct. Coincidence in time is sufficient. The government must show a substantive, I'm crying, a substantive or contextual connection between each specific lyric and the charged offense. It has not done so. The supplemental notice groups the music evidence into broad categories of admissions, but does not explain how any particular lyric goes directly to an element of the underlying charges. On the current record, the music evidence could be related to any number of unrelated stories, narratives, or creative themes. The government has not shown that the music evidence is necessary to tell a coherent story of the charged conspiracy. The government does not assert that it would be unable to present its case without lyrics or videos, merely that the evidence allows the government to present a complete story to the jury, unless the overall story would be incomprehensible or incoherent without the evidence. The coherent story exception does not apply. Nothing in the supplemental notice indicates that the government needs rap lyrics to explain the alleged conduct. What is particularly telling that the evidence is not needed by the government to tell the story is that the specific songs referenced by the government in their notices has changed from one notice to the next. If the song was so important, they wouldn't abandon it and replace another at each opportunity. They talking shit. It is as if the government has sifted through the hundreds of songs of the defendants and just said, we can make this one fit our narrative. Let's use it. Because the music evidence is neither part of the charged transaction nor necessary for the government to tell a coherent story, it is other acts evidence subject to Rule 404B. 404B's 2020 amendment heightened the government's notice obligations in criminal cases. The rule now requires the prosecutor to articulate in the notice the permitted purpose for which the prosecutor intends to offer the evidence and the reasoning that supports the purpose. The amendment principally imposes additional notice requirements on the prosecution and eliminated the prior requirement that the defendants requested notice. Under the prior rule, courts understood the general nature standard to permit the government to satisfy its obligation without describing the specific act or explaining the relevance of the evidence to a non-propensity proposed. That's funny. We're going to end it right there. So far, what we're understanding that Drew and the team are writing for Durk and DEDE is basically this. Y'all said this music is so goddamn important, but y'all got rid of certain songs. So how is it that y'all did y'all homework on these songs, but you're throwing out songs while you presented it in the first superseding indictment, but the second superseding indictment, yeah, Durk coming home, bro. End of the story. Durk coming home. Because at the end of the day, right, and y'all can say, oh man, well, they was in the videos and they was toting guns and they was dropping rakes and throwing up their gangs and all of this crap and everything. And I understand where you would be coming from. But what I can understand is how the hell the government decided that at one point in time with the Jackie Boy and Wonderful Life or whatever the hell song that Lil Durk did, that shit was months before. See, the government is lying. The government knows that we got people who we have a strong case against, aka the shooters, and then we have Lil Durk. Because if Lil Durk was able to sever his case away from everybody and was to go first, which if I'm Drew, that's exactly what the hell I'm doing. I'm looking at this damn case like, y'all first said it was text messages and coded language. And some of y'all say, well, that shit still exists now, so don't let that go over your head. Right. But now y'all talking about music. It should be nothing but recorded conversations like y'all said, snitches like y'all said, and all this fight bullshit that y'all said. Why the hell does music have to come into it? All you're going to do is make the trial last longer, like Drew said, and it doesn't mean shit. But the judge is going to allow some lyrics. But if I'm Drew in the team, I'm done warning these people. Because what I'm going to do, if I'm the lawyer, which I'm not, I'm just a hood lawyer. I'm not a $1 billion attorney like Drew Finland. He's the GOAT. I seen that shit where the little dude was shaking his ass for Brian Steele, but I'm sorry. I watched Brian Steele in multiple goddamn cases, and he didn't win none of this shit. It all boiled down to a plea deal for Young Thug and Diddy found guilty. But some of y'all would say, well, the charges could be worse, and you would be right. Bruh. Nah, not good enough. Not good enough. Won't work. Not good enough. Not in my opinion, it's not gonna work. Because the best thing that Lil Durk has is that this shit is in California. Thankfully, they didn't murder goddamn SR or Lil Pop in goddamn Arizona or New Mexico or shit, Utah or some shit like that. Thank God he didn't do that. You in hippie ass California, bruh. West Side? You feel what I'm saying? So you gonna have a good chance with them goddamn lyrics. You just are. But the question remains. The government needs to figure out this shit when the damn songs came out, because y'all gonna get your asses embarrassed. That's what Drew is sitting on, and he's telling the government, oh, bro, hey, shit. Y'all finna bring up songs, y'all don't even do your goddamn homework on it. But the government said some shit that was very telling and was very scary. Y'all know y'all played basketball all goddamn day. Y'all played football all goddamn day. Some of y'all played baseball. You know Steph Curry's three-pointer is his best part of his game. You know it's coming. You know this shit is coming. That's what he does. He shoots threes. He makes floaters. You don't watch goddamn Patrick Mahomes and all of these other goddamn players. You know how they do in the fourth quarter. So you know if you have a 3-point lead or a 10-point lead, you ain't win no goddamn game. And in baseball, you can know that somebody got a fastball that runs 102, but it's like hell to hit it. The government is saying, we don't want to show you our fastball. We don't want to show you our quarterback. We don't want to show you the 3-point shot. While Drew is saying, and the rest of the world is saying, y'all making a damn case. It shouldn't matter what the hell in what's cuz name? Paige Reese Whitaker said the same shit. It should not matter. Fonnie Willis agreed too. It shouldn't matter if the defense knows your strategy. If your shit is right, doesn't matter. That's like me basically introducing some shit against one of y'all, and I say, hey, he stole this shit. I got it on camera. But then I say, oh yeah, I don't want to show y'all that he actually pulled up in this particular car, and the car is how I caught him, not just the damn stealing itself. Or her, because I got a lot of ladies that watch this shit. The government ain't proved this case. They just made this shit sound good. Subscribe, turn on that bell, stay notified, share to keep your people aware. Hit that like button like you like some. I know this is a longer video, but y'all said y'all like longer videos. But if you don't, then we'll keep all this shit condensed down to like 15 to 18 minutes. But if you can, man, comment your thoughts, and the like button goes a very long way. I appreciate y'all, and I'll catch y'all in the next one.